En esta sesión solemne de cierre del programa Derecho y Sociedades en el sur de Chile, perdón, este programa, el programa Derecho y Sociedad de mentoría en Derecho y Sociedad, quiero agradecer a cada uno de los presentes que se han dado el tiempo de venir. Yo sé que cada uno está metido en un tema, cada uno especialmente sin jerarquía, cada uno es muy importante, cada uno de ustedes que nos acompaña hoy. Realmente le agradezco este programa. Quiero decir, ha sido el primer paso de un intento de reactivar una agenda de Derecho y Sociedad que quizá desde la gestión del rector Eugenio Velasco se había eh, perdido un poco en la Universidad de Chile, como nos ha presentado en su masterclass sobre Derecho y Sociedad en Chile el profesor Salvador Millaleo. Ojalá podamos seguir con nuevos convenios, con nuevos otras universidades, con más universidades, constituir una red donde nadie, digamos, tiene la pelota, es el dueño de la pelota y se la lleva a la casa, donde sea realmente una red horizontal y colaborativa. Hay algunos planes de seguir eso, de constituir una red latinoamericana de Derecho y Sociedad como un Collaborative Research Network vinculado a Law and Society Organization, que estamos organizando con algunos colegas que están conectados desde Florida en Estados Unidos. Y en respecto a ellos, muchos hablan castellano, pero voy a pasar al inglés. Good evening, ladies and gentlemen. This is our last session of the Chilean Law and Society Mentoring Program. Before introducing our distinguished speaker, I just would like to acknowledge that this program is supported by the Law and Society Association, and that University of Chile is hosting this as like the first interaction between these two institutions, but that now it is important to say University of Chile is becoming part of a network of institutions which are members of Law and Society Organization. And the Law and Society Association is the biggest organization of Law and Society scholarship in the world. It's the biggest network. So it's very relevant that by means of this program, University of Chile is becoming part of this network. And just a couple of words about our speaker. All of you might know him. I think it is not necessary to introduce him, but I'm going to introduce him. Well, Professor Tamanaja is one of the greatest social legal and jurisprudence scholars, I think, alive, which are alive today. He's been trying to get social science theory together with legal theory. He's been trying to get a little further than most social legal scholars and legal scholars, pure legal scholars, go when they are dealing with social theories. He has a very unusual knowledge about social theory and also about epistemology. It's very difficult to find, it's hard to find a scholar in our legal academia, which is very dedicated to issues about epistemology. And Professor Tamanaha uses epistemology of his own American tradition of pragmatism in order to get social theory together with legal theory. So he's a Harvard SJD. He's a PhD in law by Harvard. He's a professor at Washington University at St. Louis. And he's been writing many books, many books. I guess up to date there are 10 of them, 10 books. I have a couple of them here in my bag to get a little signature later on them. And about 80 academic articles, 80. And he's going to give us our last lecture today. So, Professor Tamanaha, I want to say we are very grateful you're here. Moreover, because he's accepted to come to Chile after his daughter's wedding in New York, and he just arrived last night from his daughter's wedding. So such a big day in a man's life, and then he accepted to come to Chile, and we are very honored you're here, Professor Tamanaha. Thank you very much. We hope we can constitute an audience which deserves your attention. So the floor is yours.
Thank you, Joe. I'll stand over there. It's easier for me to speak standing.
Yeah, you can go ahead. Bruno.
Thank you for that generous Pablo, for making all of the arrangements. I'm honored to be here, and I like the introduction because I don't fit in any particular existing group. I'm sort of at the margins of lots of different groups. So let me just say a little bit about that. I actually began my career as a lawyer. I worked as a lawyer for 5 years. I worked for a judge. I was a public defender, and I worked in Micronesia. And it was after that that I went and studied legal philosophy. And I think that combination is what maybe explains the fact that I don't fit with anybody in particular, but what I'm trying to do is span all of these different audiences. And that is reflected in these various works that I've been developing. So in a sense, I'd like to say I'm not really a law and society scholar. I don't do empirical studies. Instead, what I am is just a theorist who's trying to understand law. And it seems to me the only way to understand law is to understand how law has developed over time, the history of law, as well as to understand how law interacts in society. And this is about the sociological orientation for law. So the topic for today, what I'm trying to do is I put together sort of foundational account to try to keep all of these pieces of what I'm doing together and make sense of it. I'm actually still trying to figure out how it all makes sense. So I'm happy to have this opportunity to present it, and I'm interested in what your feedback might be. So as John mentioned, my starting point is philosophical pragmatism. It's a very straightforward philosophy, and it helps me understand what it means to talk about facts, to talk about truths, and also to talk about how we understand law in, as I will say later, instrumental terms. So the topics I'm going to cover, hopefully relatively quickly, in order of pragmatism, and that's because it's the foundation. It's my understanding of epistemology, how we figure things out. And then I'll move to naturalism, and I'll define each as we go along. And then I will focus on historicism and holism, and those relate to viewing law in historical terms, and holism viewing law in sociological terms. And then I will take up the social construction of law, and I'll use one example to play out the implications of that, and that is legal pluralism. So I'll talk a little bit about legal pluralism, but that's not going to be the main focus of the talk. And then I will very quickly talk about three other topics, which is instrumentalism, power, how we consider power, and the importance of ideals. So it's very broad, and I hope I'm going to make it, but we'll begin now. So pragmatism, and as John mentioned, is an American philosophy. Charles Sanders Peirce, William James, John Dewey, George Herbert Mead, these are the main figures. And what the pragmatists that they wrote towards the end of the 19th century and the beginning of the 20th century, they were influenced by Darwinian evolutionary theory, probabilistic explanation, and they were very focused on science and the scientific model of inquiry. And one of the points that they emphasize is that scientific inquiry is just the same as everyday inquiry. It's just extended into a specialized area. So science, in other words, is continuous with all human activities. So let me just lay out some of the few ideas, and that is on a very simple level, humans engage in actions within natural environments as well as social environments. We follow habits and customs, we use tools, we act on concepts, beliefs, and theories, we pursue objectives, we learn from failures and successes, we adapt to changing circumstances, and we build a collective corpus of knowledge, incorporated within language, ideas, concepts, theories, practices, all of these things. At any given time, the overwhelming bulk of knowledge in society is the legacy of previous actions, past successful actions. New discoveries, ideas are added to, and they modify and they replace what came before. Now, like all species, humans have natural traits and natural needs, and we engage in activities within these environments focused on, at a very fundamental level, surviving, procreating, and improving the conditions of our existence. Dewey wrote, quote, "Man lives as animals live, eating, fighting, fearing, reproducing. And as he lives, some of his actions yield understanding and things take on meaning, for they become signs of one another, means of expectation and of recall, preparations for what's to come and celebrations of what is gone." So reasoning, language, knowledge, values, social institutions, everything we have around us are within nature, not separate from nature. And all social institutions themselves are, in this sense, naturally produced. Yet pragmatists present what I would call a processual vision of human social existence, and that's about us continually acting, pursuing objectives, and evolving as we go along. Okay, so for the pragmatists, and now let me just talk about truths. In today's world, at least in the United States, people have alternative facts. That's not what this is about. Pragmatism actually says what truth is, but truth was with a small t rather than absolute truth with a capital T. So here is the pragmatist view of truths, and this comes from William James. True ideas are those that we can assimilate, validate, corroborate, and verify. False ideas are those that we cannot. The facts that we see are framed by our concepts and theories, and they're subject to and disciplined by an external reality. Quote, "Our ideas must agree with realities, be such realities concrete or abstract, be they facts or be they principles, under penalty of endless inconsistency and frustration." Dewey added, "If ideas, meanings, conceptions, notions, theories, and systems are instrumental to an active reorganization of our environment, to a removal of some specific trouble or perplexity, then the test of their validity and value lies in accomplishing this work. If they succeed in their office, they are reliable, sound, valid, and true." So the pragmatic method from the very beginning was empirically oriented. They focused on our experience in trying to work things out, observation of consequences, and evaluating the consequences that follow. Now, one important thing to say here is that the pragmatism was not a subjectivist theory that bases on individuals can believe whatever they want. That was an early criticism of pragmatism. That's just simply wrong. First, James and Dewey accepted, quote, "that there is a real world out there that is independent of us, that is independent of our subjective opinions and prejudices. We acquire truths about the world through our social practices of justification within communities of inquirers, involving experimentation, corroboration, verification, and attempts at falsification. Truths found reliable for certain purposes might later be superseded in the course of acting on new theories and projects. And that's for this reason that truth itself can be considered valid, but has to be open to revision. In their own lifetime, and just to explain where they got this view of truth from, they had observed recent shifts in scientific paradigms, and that taught the pragmatists that theories previously thought to be absolutely true, like Newton's mechanics and Euclidean geometry, are actually theoretical frameworks that partially construct the facts that they find. New theories, they observed simply by developments that were happening at the time, like Einstein's relativity and non-Euclidean geometry, give rise to different sets of facts, explanations, and predictions. The value of the theory depends on the extent to which it advances interests and objectives. Here's a quote from James. Theories thus become instruments, not answers to enigmas in which we can rest. So this is them understanding that these theories are valid because we take actions and we make predictions and we observe the consequences of them. And if they prove reliable, then we'll stay with them until these theories are refuted, or some development comes up that's unanticipated. We have to figure out a new way of framing and understanding what's going on. A big part of this observation is about, actually I should say this differently, the thrust of what their analysis of truth was aimed at challenging philosophical approaches that prevailed at the time. And these approaches proclaimed universal, necessary, absolute truths. That is the view that they were challenging. As James explains, quote, they turned away from abstractions and insufficiency, from verbal solutions, from bad a priori reasons, from fixed principles, closed systems, and pretended absolutes and origins. Turns towards, this is James talking about the pragmatist, he turns towards concreteness, adequacy, towards facts, towards action, and towards power. Dewey wrote, the world in which philosophers put their trust was a closed world, a world consisting internally of a limited number of fixed forms and having definite boundaries externally. But we live in an infinitely variegated world, so multiplex and far-reaching that it cannot be summed up or grasped by any one formula. This is a conception of a universe whose evolution is not finished, of a universe which is still, in James's terms, in the process of becoming, of a universe up to a certain point still lasting. So this is the philosophical view that underpins my understanding of knowledge and truth, what truths are. Now, I'm going to take the next step and apply this set of understandings to naturalism. And as I said, I'll speak about holism, historicism going forward. And as I cover each subject, this is the background understanding of my mind that I picked up. So naturalism, let's look at that for a moment. Naturalism has multiple meanings, and the particular approach, I take a minimalist or a core sense of naturalism, and that's basically the idea that we just focus on natural phenomena. There may be supernatural phenomena that can't be grasped by this. Naturalism says we are looking at things that occur within natural processes. From a biological standpoint, naturalism situates humans as social animals within evolutionary processes that are common to all species. The main distinction for us is that we have an advanced intellect and a sophisticated language and tool-making capabilities. And it's these particular characteristics which have given rise to culture, technology, social institutions, and vastly more. Now, as a part, viewing us as the natural social animals that we are, we need food, we need clothing, shelter, we reproduce. We're physically vulnerable, we're roughly equal in our abilities, and we live in potentially dangerous environments with limited resources. We're self-interested, but we're also altruistic towards others. We compete with each other, but we also cooperate with each other. We create shared meaning, and we act to achieve a myriad of objectives to meet our needs and desires. Now, naturalism, I just summarized in a very minimalist sense, has many implications for law. And we see these developments that are playing out in various areas now. So I can just give you a brief sampling of the kinds of things that are now viewed in naturalistic terms. So, for example, let me just start with the idea that law manages the basic conditions of human existence. Anthropological and psychological research has confirmed a number of human universals, although all human traits have a great deal of cultural variation in their expression. But what are these universals? Well, some are, we all live in groups. We have shelter, we have tools, we have music, we have aesthetic standards, we have gift giving, we all have cosmologies. These are, again, just a list of universals, but law also there have been observed to be universals. Again, I want to reemphasize with a great deal of variation. That relates to property rights, prohibitions against murder, redress for injuries, marital relations, inheritance, sexual restrictions, debt obligations. So all human societies have versions of this, and again, in a very minimalist sense. Punishments for infractions. Now, these natural traits have roots in human traits, but also roots in the requirements of social cohesion. Now, let me take on, adding to this, studies have also shown that rules and institutions on these basic matters, and now I'm focusing on the legal matters, but again, what I'm saying applies to other things. They're undergirded, these universals, by natural factors. So there's a leading theory today associated with Jonathan Haidt that proposes that humans have evolved subject to natural selection to possess moral intuitions, immediate, automatic, and often emotional reactions to situations. There's these intuitive moral judgments, the theory is, enhance group cohesion and survival. Another theory, articulated by a law professor at Georgetown, John Mikhail, proposes that our own cognitive systems through evolution have been structured in ways that generate mental representations and moral reactions involving rules, concepts, and principles, and it's done a number of studies to show this. This moral faculty, he calls it, is evidenced by studies that show that even very young children exhibit, quote, intuitive jurisprudence. They distinguish intentional from non-intentional acts, they use proportionality to determine punishment, and they make other sorts of legal distinctions. Things like obligatory, permissible, permitted. Now, again, these are just theories, and there's much more research that's necessary to verify this, and these are actually competing theories, so we don't even know which of the two, if either of them, or maybe something else is correct. The point I'm raising is simply that this kind of work is out there that's tying natural traits to actual natural elements of us and who we are. George Herbert Mead, who I mentioned earlier as one of the developers of pragmatism, identified criminal punishment with a hostile instinct. And let me just read what he said about this. The revulsions against criminality reveal themselves in a sense of solidarity with the group. A sense of being a citizen on the one hand excludes those who have transgressed the laws of the group, and on the other hand, inhibits tendencies to criminal acts in the citizen himself. The great and famous Adam Smith, economics, likewise identified law with natural reactions to justice. Here's a quote from him. Fraud, falsehood, brutality, and violence excite reactions of scorn and abhorrence. This is Adam Smith. And murder and theft and robbery call the loudest for vengeance and punishment. This innate sense of justice, Smith said, is the main pillar that upholds society, without which it would crumble. Nature, again I'm quoting Smith, has implanted in the human breast that consciousness of ill desert, those terrors of merited punishment which attend upon its violation, as the great safeguards of the association of mankind, to protect the weak, to curb the violent, and chastise the guilty. Interestingly enough, now they speculated about this 3 centuries ago now, and recent neurological studies have begun to verify some of these speculations. It's just observations that they made. A neuroscientist, Robert Sapolsky, observed, quote, the decision to punish the passionate motivation to do so is a frothy limbic state, talking about an area of our brain that's reacting to probe them. And they put up scenarios for them and observe how people react to these scenarios. One study found that when citizens administered punishments to norm violators, their brain linked, the area of the brain linked to pain, anger, and disgust are activated. Here's another quote. It turns out that people not only passionately wish to see wrongdoers and layabouts punished, they're also willing to take part in administering justice, even at a cost to themselves. So that's one set of implications about naturalism. Let me shift to another area. I'm just trying to show that there are all kinds of implications that we're just beginning to think about and learn about. But one of them is the very emergence of law itself as organized complexes of rules. This can also be understood in evolutionary naturalistic terms. As populations have increased in size, activities involving the coordination of social action within large groups gives rise to institutions. That's what law is, an institution. Of course, there are many other institutions being created. And These institutions reflect natural human traits, like, for example, drawing in-group versus out-group distinctions, hierarchy among society, and other naturalistic aspects. And when I say naturalistic, let me just add, and I'll refer to Sapolsky again for this. He was not only a neurologist, but he's also a primatologist, and there are people that are studying behavior of higher level primates and identifying common elements of behavior among primates as well as humans. Some early anthropological studies, of early human societies, things like chiefdoms or early states, shows that these institutions emerged, these early institutions emerged supported by legal coercion. And they were utilized to coordinate major tasks, food cultivation, defense from outsiders, as well as to maintain political domination and internal order, as well as enforcing social and economic hierarchy. So what are legal systems? Legal systems provide the enforcement muscle, I can use that term, that backs ruling polities as they entrench their control within the social group, while also enforcing basic rules of social conduct. Now let me give you another example. And again, I'm just running very quickly through these possibilities. One I've already just briefly alluded to, and that is about hierarchy. Primates show hierarchy. Humans have hierarchy as well. Quote, humans are just like numerous other social species in terms of having marked status differences among individuals and hierarchies that emerge from those differences. The differences is that humans belong to multiple hierarchies attached to different criteria: wealth, gender, religion, caste, and so forth. Okay. Now let me just jump into another area just to again show you the range of possible insights. Naturalism also bears on concrete issues within law. Genetic research and neurological studies, for example, have uncovered evidence that certain individuals may, for biological reasons, be prone to violence, and biological as well as interacting culturally, as well as interacting within your own family and so forth. All of these are complicated and multi-causal, but aspects like pedophilia and other social acts. And these findings bear on criminal punishment. The relevance for lawyers is, what do you do with this knowledge when you discover it has these natural elements to them? And one aspect that's playing out in the United States more, although not yet fully, is that studies of brain development, we all know now, suggest that teenagers should be treated differently from adults for the purposes of civil and criminal punishment, because their brains are not yet fully developed. They don't have the same level of judgment that adults do. Naturalistic studies are also behind discoveries that are now commonplace but weren't 10, 15 years ago, and that's ideas of subconscious biases, in-group versus out-group judgments, motivated reasoning, ideological influences. These are all things that we're now taking up in relation to studying judicial decision making. Now, again, I want to emphasize, and I'm just running through some of the implications of naturalism, that it's important to say these are not fixed. We have natural traits. They're not the same. They're not universal in the sense that everyone has them the same way. They are thoroughly infused with social, cultural, economic, and political influences that are surrounding them, and they vary greatly across society. In addition, contingency is an element of our existence. And the pragmatists acknowledge all of this. In fact, James really talked a lot about pluralism. The point is there's both natural factors and plasticity at play, and all of these things are combining in very, very complex ways. Okay, I'm sorry I have to keep talking quickly, but I want to move on to talk about historicism and holism. That's the title of the talk that I had provided for you, because I think at a level of application, for me, these are the two fundamental ideas that play out. So historicism takes the position that law exists temporally. It just means stretched out over time, extends from the past to the present, and it projects towards the future. This is true in a very narrow sense that positivist lawyers don't often think about or actually are conscious of, which is that the law that comes into existence at a given moment applies going forward until it's taken away. So law itself has a temporal component built into it. But it's also true, historicism, in the broader sense, and this is something familiar to legal theorists and historians, that law itself is a historical product. It's an inherited tradition. And that inherited tradition changes over time in relation to surrounding factors. So at any given time, the law that exists has been shaped by the past of that society. So again, this looking at law in this way is historicism. So Oliver Wendell Holmes, who did historical work under common law, wrote, quote, "The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it is contained only the axioms and corollaries of a book of mathematics. In order to know what it is, we must know what it has been and what it tends to become." Now, the historical lens, just like naturalism, can be used for multiple purposes. You can apply it in all kinds of different ways. So one way, and a common way, and one that he did, was to use it to trace out the social factors that influence the development of law, to help us understand it. To know what law is today, we just look at the historical development to see how it became this. A historical lens can also be used for legitimation purposes. For example, by arguing that the longevity of a given legal regime reflects its beneficial effects for society. This is an old explanation. We still have it. It's been good for 200 years. It must be good because it's good. That's why we had it. But another way to use historicism is to undermine the legitimacy of law. For example, by demonstrating that its origins were bad or arbitrary, and that the law was kept in place through inertia, through blind traditionalism, or just fictional rationalizations that were made up afterwards to explain why that's the law. It can also be used to show that although in an earlier period a given law was good, it actually was very beneficial. Surrounding circumstances have changed while the law has lagged, and that it no longer meets existing needs. In the 19th century, there was a school of jurisprudence attached to these ideas, and it was called, naturally, historical jurisprudence. And this can be applied on the grand scale. Sir Henry Maine, if you've heard about him, his account of the evolution of law from status to contract is a perfect example of that. But it can also be applied at the level of legal concepts and doctrines. And again, Oliver Wendell Holmes is an example. He argued that the common law has progressed from subjective to objective standards as a progression of, as law progressed, it moved in this direction. So the historicist methodology, historicism, is genealogical. It focuses on where that law came from and how it developed over time, as well as comparative, looking at other societies or looking at your own society at different stages, observing continuities as well as challenges. Okay, let me shift to holism then. So holism emphasizes that law, and now I need to use metaphors to talk about it, but holism emphasizes that law extends spatially throughout society. Or the way I like to talk about it is that law is interconnected with everything, with culture, the economy, the polity, social structures, technology, legal system, everything. Now, the interconnections of law are mutually constitutive, and what that means is that social influences affect law and infuse through law in a multitude of ways, but also on the other end, that law itself gives rise to and stands behind a multitude of social arrangements. Law is integrated within the social whole, constituting as well as constituted by surrounding factors. So again, that's holism. It's important to note that holism and historicism espouse the same core view of law as integrated within society. The only difference is the former, the one emphasizes the temporal dimension and the other emphasizes the spatial dimension. Just as historicism had a 19th century jurisprudence school attached to it, historical jurisprudence, the holistic perspective also had a jurisprudence school attached to it, and that was the early 20th century school of sociological jurisprudence, which was prominently promoted by Russell Pound. And again, his objective was the same, to fight excessive abstractions and conceptualism in analytical jurisprudence. Pound explicitly identified his approach with the pragmatists that I just mentioned. If you look in his articles, you'll see references to James and so forth. So the holistic approach, or we could just call it the sociological perspective, emphasizes that all of these surrounding factors, moral views, cultural, religious views, economic factors, political forces, clashes among competing groups, all of this, technological advances, seep into and shape law in every place you look. At the same time, law undergirds corporations, economic transactions, structure of government, property rights, remedies for injuries, rights of employees, everything we see today. Now, owing to these interconnections, and this is something Pound endlessly repeated, you cannot view law in isolation of surrounding social factors. you do, you have a very artificial understanding of what law is. And the methodological implication of this point is that to understand the reality of law, what law actually is and what it's doing, requires the social scientific study of law in action and its social consequences. This is, by the way, the insight that lies behind the law and society movement. So and just to give you an example of how this plays out, both of them, historicism and holism, only a historicist and holist perspective can tell us why the rule of law that we're all talking about in all societies around the world, how and why the rule of law developed can only be explained through historicism and holism. And in addition to that, with this, you need this perspective to explain another thing that's just mysterious to legal philosophers, which is that the reality of the rule of law societies, US, France, Japan, Singapore, Chile, consist of very different complexes of legal institutions. There's no rule of law society that's set up the same way. None. Look at all of them. They all have all these variations at all these different levels, and it's actually really hard to identify specific institutions that are common. There's no single rule of law institutional arrangement. Another thing this explains historicism and holism that we've seen before is legal transplantation is common around the world. It's one of the ways the world spreads. But frequently, when law is transplanted from one society to another, it doesn't work in the same way. Actually, often it doesn't work at all. So it's holism and historicism that tells us where we need to look, and that helps us explain and understand these factors. Okay, now I'll switch to the next topic, and that is law as a social construction. Doing okay. I won't repeat, but again, I'm going to emphasize that the ideas that I'm laying out come from pragmatism. And to do that, I'm going to use a quote from George Herbert Mead. George Herbert Mead, James and Dewey and Peirce were the philosophers of the movement. Mead was the sociologist of the movement, although he worked closely with Dewey. Or not worked, but they engaged and worked at the same time at Chicago. So Mead applied this perspective to property rights. And I'm just going to read this extended passage so you can see what it means to look at law as a social construction. So here's a quote about how we create law through create property through collective recognition. Again, this is from Mead. The institution represents a common response on the part of all members of the community to a particular situation. This common response is one which, of course, varies with the character of the individual. In the case of theft, for example, the response of the sheriff is different from that of the attorney general, and from that of the judge and the jurors, and so forth. And yet they're all responses that maintain property, which involve the recognition of property rights in others. This is a common response, that's what we call it, a common response, but in varied forms. One appeals to the policeman, for instance. One expects the state attorneys to act, and one expects the court and its various functionaries to carry out the processes of the trial and of the criminal. Such organized sets of responses are related to each other. If one calls out the response of one, he's implicitly calling out the response of the others as well. Thus, institutions of society are organized forms of group or social activity, forms so organized that the individual members of society can act adequately and socially by taking the attitudes of others towards these activities. So his basic idea is that we have social institutions are created through shared expectations that basically link up. People who work within these organizations, and these organizations are based on conventionally recognized roles, rules, responsibilities, practices, and all of that. These activities are joined with others. It's not necessary for everyone to know what everyone else is doing. You have a picture of the whole. People within the institutions don't know what everyone else is doing. People external to the institutions don't know what every individual is doing, but we all know it hangs together in a general sense. Now, a critical point about Mead, and this is something all the pragmatists emphasize, is that he emphasized that people's actions are not strictly determined by their roles and responsibilities. Like all pluralists, he emphasized a pluralism of perspectives among individuals. And these general patterns, I'll quote again from Mead, provide plenty of scope for originality, flexibility, and a variety of such conduct. So people operate within roles, following rules and institutions, but he also emphasized that in the course of doing so, they can also be creatively modified, extended, breached or ignored, as often occurs, along with being followed, and that there are degrees of indeterminacy and contingency. He also emphasized, or generally, that informal norms can be just as influential as formal norms in shaping actions. He also urged recognition that these social institutions don't all work in a tight-knit, coherent way. Here's a quote. Each social institution with the good that it subtends asserts and maintains itself, but finds itself in that assertion in conflict with other institutions and their goods. Now, the crucial factor in the social construction of law, but not, I'm talking about social construction of everything, the university, everything, is conventional recognition within a group. And conventional recognition, and now I'm talking about law specifically, tells us who counts as legal officials, which specified legal powers they have as judges, as lawyers, judges, prosecutors, and what they must do for their actions to count as legal. So collective recognition is undergirded by conventional understandings of what's going on. I was going to give another example, but I'm taking too long. So instead, I'll just give you one example and say a little bit about legal pluralism. Because legal pluralism, the grounding for legal pluralism is collective recognition. So let me just ask a fundamental question that I think lawyers often don't think about, which is, what makes state law law? Why is state law law? It seems like a bizarre question to us because we just take for granted that it's law. Now, a constitutionalist might say, well, state law is law because the Constitution says so, and the Constitution is the foundation for law. But if you say that as your answer, I'm just going to ask you, okay, well, what makes the Constitution the foundation of law? You see, we could just keep on going. And the answer bottoms out in this. State law is law because people within society collectively recognize state law as law. The Constitution is the foundation of law because people collectively recognize the Constitution as the foundation of law. So the crucial existence condition for state law, now I'm only talking about state, I'm going to go on in a moment, is collective recognition. Now this is not my insight, it comes from H.L.A. Hart in his classic book, The Concept of Law, when he grounded the ultimate rule of recognition in social conventions. The problem is that Hart stopped there. He just assumed that most people in society view state law as law, and then he says, okay, therefore it's law. What he should have done is that recognized or asked whether people collectively recognize any other forms of law. So in other words, instead of stopping at that point, go further. For example, why is international law law? Well, because many people in many societies recognize international law as law. And this recognition collectively gives rise to international law institutions. But maybe we can even go further and say that in many societies, customary law, especially societies across the global south, customary law is an important form of law. Why? Well, because people within those communities collectively recognize customary law. I'll give you another one of great historical importance, and that's religious law. Religious law exists within communities around the world because people collectively recognize religious law to utilize and arrange their affairs, Islamic law, Hindu law, Jewish law, Christian law, canon law, ecclesiastical law. All of these are collectively recognized forms of law. Now, there's nothing about state law that sets it apart, just at this foundational level. Obviously, state law has no power. So I'm not saying they're the same. I'm saying their foundation is the same. Their foundation is in collective recognition. Now, their legal officials will say, well, they can say whatever they want, but that doesn't make it true. And I'm going to say the state can say whatever it wants, and it doesn't make it true. And I'll give you an example, and the example is religious law. Just in the United Kingdom today, over half of marriages among Muslims are not registered civil marriages. They only marry under Islamic law. And from the standpoint of the state, these couples are not married. However, from the standpoint of Islamic officials, these couples are married. And just to give you an example, this is a fatwa, a legal ruling from on divorce pronounced by the Islamic Council of Europe. The fatwa states, quote, the divorce issued by the civil court in response to the wife's request is neither a valid divorce nor legitimate marriage dissolution. This means that such a wife, the one who got divorced under civil law but not under Islamic law, this wife remains a wife and is not free to marry another man. Marrying another man while the original marriage is in place is a violation of Islamic law and the crime. The fatwa goes on to state that any future children this woman might have will be considered the children of the first husband. Now, on its part, the state takes exactly the same position. There's a state court ruling in England that says nikah, Islamic marriages, are not valid marriages and have no legal effect. So my point is, whatever either side is claiming, ultimately, they are still recognizing their own form of law, and people within communities that abide by those forms of law take those forms of law as binding. Now let me give you an example of customary law. And this is a summary from a World Bank report. Quote, in many developing countries, customary systems operating outside the state regime are often the dominant form of regulation and dispute resolution, covering up to 90% of the population in parts of Africa. Customary tenure covers 75% of land in most African countries, affecting 90% of land transactions in countries like Mozambique and Ghana. In many of these countries, systems of justice seem to operate almost completely outside the official state legal system. That's a quote from the World Bank report. Let me give you another quote. This is from the New Zealand Law Commission. They did a major and excellent study on customary law throughout the Pacific. I'm trying to show you it's not just Africa in which this involves. And so here's a quote from the report. The vast majority of disputes in many Pacific countries, especially in Melanesia, are resolved by customary means. Many states depend on custom to maintain local peace and order and have not the wherewithal to replace it with state institutions. Okay, I was going to say more about it, but I will skip all of that. Just to say that there are differences between these systems, but I'll leave that aside. Let me get back to, let me now go back to the discussion of pragmatism and these subjects. I just wanted to go a little bit down that path just to show you the implication of viewing law in terms of collective recognition. So I'll pick up again and focus on the ideas of instrumentalism, power, and ideals. So pragmatism holds an instrumental view of all social institutions. This is not just about law. This is about society and social institutions generally. So Mead emphasized, quote, that institutions are the tools and implements of a community. Dewey wrote, now it's true, and Dewey actually did work on law. He taught at Columbia Law School, so we have some writings from Dewey on law, which are really superb. Now, so Dewey wrote, quote, now it's true that social arrangements, laws, institutions are made for man, rather than that man is made for them, that they are the means and agencies of human welfare and progress. Quote, he continued, law is through and through a social phenomenon. Social in origin, in purpose or end, and in application. Again, I'm quoting, a given legal arrangement is what it does, and what it does lies in the field of modifying and or maintaining human activities as going concerns. So it follows from this perspective. Once you start viewing law as an instrument, now again, this is the instrumental view of law. In fact, Dewey's label for pragmatism was instrumentalism. It follows from seeing law as an instrument that one must know the consequences of law, otherwise you can't see what this instrument is doing. And in addition, it follows that law must be evaluated in terms of whether it successfully achieves desired ends, as well as whether those ends are socially beneficial. Again, I'm quoting Dewey, for it demands that intelligence, employing the best scientific methods and material available, be used to investigate in terms of the context of actual situations, the consequences of legal rules, and proposed legal decisions and acts of legislation. So this is Dewey saying, look, if law is an instrument to achieve objectives, of course we have to evaluate it, and to evaluate it, we need to actually know what it's doing. That is, its consequences. And again, this is the sociological jurisprudence approach. This is about saying, yes, law is an instrument, we need to understand it sociologically. Now, another implication that immediately follows from the instrumental view of law, the first one being you have to view it empirically and see its consequences, is that you have to pay attention to power. And because law is not just an institution, but it's an institution, now I'm talking about state law in particular, backed by coercive force. Rudolf von Jhering, a 19th century German scholar, also asserted that law is an instrument utilized for individual and social ends. And let me quote from him. He had some actually quite brilliant writings. In the course of time, he wrote, the interests of thousands of individuals and of whole classes have become bound up with the existing principles in law in such a manner that these cannot be done away with without doing the greatest injury to the former. Hence, every such attempt, that is any attempt to change law, in natural obedience to the law of self-preservation, calls forth the most violent opposition of the imperiled interests, and with it a struggle in which, as in every struggle, the issue is not decided by the weight of reason, but by the relative strength of opposing forces. This is again an insight from Cierre. So viewing law instrumentally, and again, now seeing instrumentally and now examining power and influence, raises questions, again, immediately about, well, who controls the law and to what ends? And there are two different approaches that jurists often use. And one approach is the ideal account. This is the account I was taught in law school. This is how legal theorists often talk about law. And that view is that law is an instrument to advance the public welfare and the common good. And law is an instrument to maintain a just social order. Law helps coordinate behavior. Law resolves disputes. It brings order, stability, certainty, and predictability. And it limits the arbitrary exercise of governmental power. So legal theorists often say this, and they're right. But there's another side to law. The critical view focuses instead on law being attuned to power, to the unequal distribution of wealth and resources. And they hold that law operates as a means of domination that entrenches and enforces social, economic, political hierarchies along various lines: caste, race, wealth and class, gender, religious, and others. This critical view is that the function of law, this domination hierarchical function, is often unexpressed or latent, although it's manifest in operation. So the critical theories focus on that. And all I'm going to say is a realistic approach, this is the approach I take, looks at both sides. Takes seriously both claims, not one to the exclusion of the other. Okay, so I just want to say about domination, as the more you look at the history of law, the more you see that law has done these things, maintain order, but you also see that law throughout its history is associated with hierarchy. I want to quote a leading scholar of state development, Henri Clausen, who remarked, quote, "There's always found," now he's looking at early states, right? "There's always found great inequality in early states. Some people, the happy few, are rich and powerful, and all others, the great majority, are poor and powerless." Law was used, both the ideology of law as well as the coercive institutional apparatus is what enforced this hierarchical arrangement in society. If you look at Hammurabi's code, you'll see that it's filled with status distinctions. We say eye for an eye. It doesn't actually work that way. The punishment for harm to elite and punishment to lower classes is different. But another example is Roman law. Roman law undergirds law in civil countries around the world. Under Roman law, the freeborn adult male was at the pinnacle of power and authority, and everyone else was arrayed below the freeborn adult male. But I can talk about the United States. Obviously, slavery law in the United States in the 19th century and Jim Crow law in the 20th century. Actually, let me talk about the United States today, because we often think, well, we're beyond all of that. The influence of wealth on law is plainly evident today, where billions of dollars in lobbying and campaign contributions flow through the political system, sent by corporations and rich individuals seeking favorable legislative and regulatory actions. By the way, now, Elon Musk is some kind of government overlord or something, so they're taking it to another level, but we will see how that goes. But I also want to talk about judicial appointments. For those of you who don't know about the United States, at the federal level, the Federalist Society, which is run by Leonard Theo, in the past decade has received over $1 billion from unacknowledged sources to create, and he's been utilizing this actually for several decades, an influential network of lawyers with economically and socially conservative views that he has then infused into the federal judiciary. And obviously, to do this successfully, he needed to have Republican presidents and Republican senates, and they had it with the first Trump administration, and they're going to have it again. But it's not just at the federal level. In recent decades, and I just mean now the last 2 decades, this was a rare thing in the 90s. And before that didn't happen. At the state level, millions of dollars are now spent on judicial elections, including $50 million on the Wisconsin election. That money, everyone, to be clear, the vast bulk of that money is coming from corporations and economic interests. Now I want to just talk about ideals, and I'll close there because I've been going on a long time. So many talk about the importance of legal ideals in the social construction of law. So this approach emphasizes, and the pragmatists as well. Pragmatism, by the way, one of their themes was meliorism, making life better, making things better for people. So this approach focuses on the prime importance of ideals espoused by legal officials and by the public as having a major impact on law and the transformation of law. Ideals about law, particularly claims that law represents justice and the common good, as well as ideals like liberty, equality, due process, fairness, provide standards to evaluate, criticize, and reform law. Resort to ideals helps us make law a better thing. Now, I've run through these very quickly. I actually had a bunch more to say, but I will stop there and suggest to you that what I've done is really just provide an overview of just a few set of ideas that if you internalize them, allow you to now see law in a particular way and then take this vision and apply it to any specific context of law that you're working on. And I think that's where the promise of this approach exists. So I'll stop there.
So much, Professor Tamanaha. Now I think we could make a little comment by ourselves as we've talked last night. I don't know if Professor Salvador wants to start. Do I step in?
Yes, bueno, ¿puedo hablar en castellano, en español? Sí. Bueno, acá estamos muy orgullosos de tener este cierre cuando se plantean este tipo de cuestiones acerca de la capacidad cognitiva que tienen los sistemas jurídicos. Los sistemas jurídicos tienen una capacidad cognitiva que es limitada y esa capacidad cognitiva se ha desarrollado, digamos, normalmente bajo el amparo del Estado y de los aparatos que estos organizan. Y esa es la mentalidad que nosotros tenemos. Ahora, cuando se nos plantean las situaciones de pluralismo jurídico, por ejemplo, que el profesor Tamanaja ha desarrollado, digamos, bien acuciosamente en sus estudios, en sus libros, sobre todo en el pluralismo jurídico explicado, nos señala precisamente que tenemos otros recursos cognitivos que podemos movilizar que no están presentes en la mentalidad o en los conceptos de derechos que tenemos, pero que están disponibles para buscar mejores soluciones, soluciones que puedan ser más justas, socialmente, digamos, más adecuadas y que puedan desarrollar mejor políticas o ciertos valores que políticamente hemos decidido dentro de una democracia. Entonces, la capacidad que tiene el Estado de abrir su propio cierre cognitivo y ser capaz de incorporar visiones nuevas, visiones distintas acerca de cómo resolver conflictos, es decisiva a la hora de ver cómo podemos crear mejores condiciones de justicia en digamos, para afrontar diversos tipos de problemas. No solo problemas que tienen que ver con pluralismo religioso, étnico u otro tipo de diversidades, sino políticas que son cotidianas, cómo aplicar ciertas políticas de familia, cómo aplicar ciertas políticas sociales, cómo desarrollar ciertos criterios de justicia económica. Entonces, en este sentido, este tipo de, digamos, desarrollos donde lo cognitivo... donde lo cognitivo se suele dejar de lado, el profesor Tamanaja nos plantea un desafío acudiendo a el pragmatismo, digamos, el pensamiento pragmático en Estados Unidos, nos ayuda a pensar que una democracia también tiene que ser una democracia cognitivamente hablando, o sea, admitir una pluralidad de formas de información, de formas de valoración, de jerarquización de problemas para poder acudir a todos los recursos que tiene una sociedad para resolver sus cuestiones o dificultades comunes. Entonces, creo que es un planteamiento que tenemos que desarrollar más en nuestros países, todavía muy marcadamente centrados en el Estado.
Well, Professor Temin, I'm going to just translate a little bit what Professor Miguel said. He's highlighting the importance of recognition of religious pluralism and legal pluralism, actually, also as a way to help our society, Chilean society, to advance in some political struggles and social conflicts which are taking place here. And so I have just a couple of questions. One will be more like a scientific epistemological comment, and the other will be like I'm going to try to make it more of a question than of a comment, which is about the use of anthropological research in the social legal jurisprudence, your social legal jurisprudence especially. So I'll call this question, I've been taking notes the whole presentation, and the one I think it actually has some sort of dialogue with what Professor Miraleu was saying about this pluralism of perspectives. And then we have a problem here because legal scholars sometimes try to embrace an epistemology of objectivity versus subjectivity. So we have this pluralism of perspectives, objectivity and subjectivity. And one of my great heroes is Bruno Latour, a French philosopher of science, and which has created actually a small field for himself called science studies. And science studies, all of the work which has been done by Donna Haraway, Bruno Latour, Michel Calon, is to say that if by objectivity we mean what do we mean about objectivity, right? And it seems like this perspective which we just seems to defend. So maybe this is a question. The social construction of law view, this collective conventional recognition view of law. And this approach will depend on accumulating pieces of evidence in favor of the impact of the recognition of law in certain social fields by certain players in the society. And that will help us to provide standards to reform law and so on. But if we take this approach of science studies, which what means science we understand like scientific evidence as a means of objection answering. So what is an evidence is what allows me to answer objection, right? So what we see here is that sometimes legal scholars try to embrace the opposite, the classical epistemological, scientific, analytical, philosophical view of objectivity, because now with climate change, with everything which you just said here, that we can accumulate as many pieces of evidence we want to say that there's lobbying, nominating people for the Supreme Court. But what do we do with that? Because actually our opponents will use this epistemology of objectivity versus subjectivity to say that we are pursuing grants for our research, we are connected to globalists, to Ford Foundation, to George Soros, and accuse us of being subjective, right? And obviously, in law, people are objective, as Latour explains in The Making of Law, in a subjective sense, like, I'm wearing a tie here. And here you see the dilettante and the scientist. Professor Tamanaha has not to protect himself against the public, that he's subjective, because he's protected by science. When you talk about law, you have to behave. You cannot speak about law without putting yourself in a certain position, right? This is the ontological view of law. And Professor Tamanaha is not subjected to this kind of critique because he's being subjective in an objective way, right? He's pursuing evidences. He's just trying to see if the object he's talking about tell him that his theory is true. So when you say that we need evidences, what is it? What do you mean by evidence? And can we depart from this? I mean, Dewey said that science needs much more than science to protect itself, needs a public life, a healthy public life. But between Dewey and us, there is a big catastrophe called analytical philosophy, which contaminated the US university system and the Chilean one also. Almost everyone here in this school is loves analytical philosophy. Who are the guys who are promoting this vision of objectivity versus subjectivity? I'm not here by saying that we should embrace subjectivity, right? I'm just saying that this very division, this very notion is completely wrong. So can we speak about law in a way we can answer objection and use our empirical work? In which ways can we do that? And finally, the second thing is that in this holistic perspective, if law is everything and everything has law built into it, what is law at the end of the day? Here in Chile, we have this idea that law is what this system of sources of law tell us: the doctrine, the jurisprudence, the case law, regulations, normative acts, right? And obviously, I think that's not enough to identify what law is. So yeah, that's it. I don't know, but if I'm making it more of a question, but what is law from that viewpoint of a social construction? If you could go a little big, I would like to hear your take on that. Thank you.
Okay, so you raised multiple big points, which I'm not sure I can answer all, but I'll take it up in reverse order from what you just asked. I think what is law is the wrong starting point, because the first question is, well, if we ask what is law, my answer is law is whatever people collectively recognize as law. At that point, we then have to shift to this question: okay, what do people collectively recognize as law? And I ran through a few of them: state law, international law, customary law, religious law. So we'll stop there. Then the question is not what is law. The question is, well, what is state law? And if you ask me that question, I'll talk about the institutional development of state law, how state law functions. It makes perfect sense to me as a lawyer, and I was a lawyer. This is why I find nothing objectionable about this, to ask, well, what's the law of divorce law in New York? Okay, go look in the books. They'll tell you what it is. And then a law and society scholar will say, well, this is how it actually works. That's what the law says, but when it's actually applied, it's not consistent. This is where the law and society perspective comes in. And in my view, you need both. I can tell you as a jurist what the law of marriage is. I can tell you as a or not I can tell you because I don't do sociological studies of law, but I can ask the law and society scholar, does it really work like that? Does it work out the way they say in the statutes? So an understanding of what state law is, for me, requires both understanding the internal operation of state law, the way the institutions function, the rules themselves, how these are all specified. And then I apply a law and society perspective to get a rounder picture to see what the actual consequences in action, right? Law and action, that's a great theme law and society actually are. So my first response to you is, I think that's the wrong question. The question should be, once you recognize that law is whatever people collectively recognize as law, you then shift to the next level and say, well, what do they collectively recognize? And then we'll take up each one. Now, when I mention religious law, I have to keep going further, because now it's not just religious law per se as a category, but specific forms of religious law and how those forms of religious law are constituted, how do they operate, and how they function. Same thing about customary law. There's no one form of customary law. You can, as a social scientist, study forms of indigenous recognized customary law and then compare them and talk about how they actually work. There's different forms of customary law. It's also different because customary law in many societies interacts with state law. So now I have to see the interaction with state law. There's some customary law forms that operate in isolation, but most of them actually operate in the same social sphere as state law. The quotes that I read you from the World Bank, although customary law handles 90% of land transactions, they're not handling it in isolation because they're also state property laws. And in fact, one of the great sources of uncertainty in property law in many of these countries is you could have title officially under state law, but under customary law, they don't recognize that title. So now you have to look at the interaction between these two forms of law on the ground. So from my standpoint, I think one of the things we need to do is start understanding law in this way, that there's no one answer to the question, what is law? That tells us just how to identify it. And then from there, we have to go to the next question. Your statement about analytical jurisprudence being a dominant form of philosophy, actually, I think that's correct. And that's correct as an institutional matter. If you study the sociology of knowledge, which I do a lot, including sociology of science, what you learn over time is that knowledge is itself socially constructed, and that a big influence in social construction of knowledge is things like institutional prestige. What makes analytical jurisprudence, or what has made it in the past so important, is, first of all, it aligns with the interests of positivist lawyers. That's what it does. It matches that orientation. But more importantly, it has institutional strongholds in the most elite institutions in the world. So HLA Hart and Joseph Raz were at Oxford. Well, so everybody wants to go to Oxford and study, and then they get PhDs under them, and they go out and they propagate these ideas. And I don't say that in a bad sense. That's just how knowledge develops. Collective knowledge in our modern world that has been substantially institutionalized, lots of dominance at any given point is a function of sociological factors. Then this isn't to deny the validity of the insights. I'm just saying we cannot look at that. The dominance of analytical jurisprudence is simply because they're right and everybody else is wrong. No, it's just one perspective. And that perspective, because it is in the most elite institutions in the world, dominates for this generation. Now, the important thing I think to keep in mind is that dominance is always a generational thing. Things are constantly changing. And I'll just give you my own work as an example. Analytical jurisprudence have pretty much ignored what I've written about for a couple decades, but not recently. Now it's beginning to change, because you can only go so far with pure analytical stuff. Pure analytical stuff is about abstractions based on intuitions and then working out implications. Okay, you've done it. Now, those of you who don't pay attention, 2 decades ago, the biggest debate in legal philosophy was inclusive versus exclusive legal positivism. You'll note you won't see much of it anymore. Look in the literature, you'll see. It has its moments, and then everybody moves on. More recent work that I reviewed from analytical jurisprudence, I'm often asked to review articles, including one I just read a couple days ago, was about the social efficacy thesis, the challenge to the efficacy thesis in analytical jurisprudence. Well, I've been attacking that thesis for 2 decades. I said it's wrong. The guidance function of law guides conduct. And I've been saying this is nothing I thought original to me. How can law guide conduct if most people in most societies don't know what the law is? In fact, we have lots of studies that show people are wrong about the law, including in the US. They just make mistakes. What they think law is their assumptions about what law would be. There are multiple studies of this, and I'll give you one specific one. It comes up again and again. People in the US believe that they have protection against being fired by their boss. Well, in the United States, they don't. You can't be fired for discriminatory reasons, but they can fire you for any other reason they want. So they have these studies where people think they have this right, when in fact they don't. Now, that's just one example, but there are many. And all I'm trying to say, all I want to say about that is law and society scholars have been pointing that out for a long time. Now, finally, I reviewed an article in which that's the topic. It's by a legal philosopher who says, hey, we should talk about the fact that people aren't guided by law. Okay, fine, 20 years later, you guys finally came to that. And the point is, not to make fun of them, but to say that analytical jurisprudence is itself changing. They're now taking up subjects that they weren't before. And this is where these ideas are beginning to seep in to how analytical jurisprudence works. Now, here's the key thing. Analytical jurisprudence, the standard mode is based on self-evident propositions, then analytically figured out. Once you move in this direction, you have to start taking into consideration social reality. That article I reviewed is citing law and society studies about the fact that people are not guided by law, but guided by their assumptions about what law is. There's a critical distinction there, by the way. And that's really, really important. So my point is, yes, analytical jurisprudence has been dominant. It may well still be in Chile. I honestly, and I'm sorry, I will apologize, but I know nothing about Chile. And I mean zero. So I will not say anything about your country or anything else. And I'm really sorry. I just never came to that. So for me, we shouldn't mistake generational dominance with inevitability. It's not inevitable. I actually think it's changing. And I'm using one article that I recently reviewed, but there are lots of indications of that. And I actually take that as grounds for optimism because this change, by the way, I'll give you one other example, a remarkable example. I was shocked when I saw this. In 2017, so Joseph Raz was all about state law dominates everything, it's supreme within society, and on and on and on. In 2017, had a chapter in a book called Pluralist Jurisprudence, in which he says, why state law? All these analytical jurisprudence, not thinking about himself, have been focused only on state law, but how can we justify that? Now there's international law, and then he starts mentioning religious law and customary law. But yes, that's right. Once Joseph Raz made this move, I will just tell you, there's no going back. There's no going back. And the reason this is important is because the only way you can talk about other forms of law is to read what anthropologists and sociologists have written about other forms of law. There's no longer armchair analytical jurisprudence. Go learn about how things are actually working. So that's another. In other words, the high priest of the recent generation of analytical jurisprudence comes out and says, we have neglected other forms of law, we need to study it now. I haven't seen a whole lot following up, but they all know it's out there. And again, this for me is like a stunning admission on his part that they have all along had a much too narrow focus and that it's going to go beyond that. Now let's talk about science. I don't really know what to say about what you said about science other than the approach I'm taking is trying to set aside claims about objectivity. I actually don't think it's a useful way to talk about anything. I think it's much better to talk about empirical studies that examine situations, try to replicate them, try to understand what they're doing. See, I can talk about all of this without the word objectivity. Are scientists objective? No. Of course not. They have views. They're shaped their methodology. They have methodological strictures, but it shapes what they're studying. It shapes how they interpret the results. This is infused, in other words, with other influences. But that doesn't fatally undermine this, right? These actions are within communities of inquirers. By that, I mean other scientists who criticize, look at, say, wait a second, that was a bad call. You let your bias infuse it. So it's the critical exchange of the community of inquirers. And by the way, this is just a pragmatism side. It's nothing from me. It's the critical exchange with the community of inquirers in combination with you looking at the reality out there and examining propositions and seeing whether or not it's correct. And how do we examine it? Well, by examining how good the study was, but also, importantly, doing other studies and seeing what they say. So there's no one study in isolation. It's also why we can never say, we finally got the truth about this. This is always how it's going to be. There's no such thing. So my response to talk about objectivities is, honestly, I just don't use that word. And if someone says to me, well, that's not an objective study, I'm going to say, well, tell us why it's wrong, instead of saying it's not objective. And then let's see, is there another way it can be done so that it's replicable, or that we have more, put it in less scientific terms, that gives us more confidence in what that study purports to show. I think social science, there was a period in the Law and Society of Literature in the 1990s in which they got twisted in knots over postmodernism and all of that. I believe personally, none of that was helpful. It was a complete distraction. And if you look at people like Lawrence Friedman, I'm pointing to because we just talked about him, just says, look, I'm trying to get it right. I'm trying to get it right, but sometimes we get it wrong. I investigate. I use as much information as I can, and that's the best we can do. Well, yes, of course. And he had opponents on the other side, who I will not mention, who says, well, everything's subjective, so it doesn't matter. If that's your view, everything is subjective, honestly, law and society has no future. Because why should anybody care? If it's all about what your own personal, political, or whatever moral views are, you're just making fake studies to prove what you believe. Nobody outside of this should bother to read it. I mean, they won't. That's why I think that was a danger to the Law and Society movement. We can accept the limitations of scientific studies, as we should. They are real limitations, without, at the same time, dismissing them as worthless. And that's the problem. And again, for me, this is the flip side of what the pragmatists were doing. What they were challenging, and this was the norm at the time, were claims about universal, immutable, objective truths. And they just said, that's not a good way of talking about it, because there's no such thing. There's human-generated knowledge, and it comes with all the foibles of humanity. It can never be clean of all these things. But you know what? It works. How do we know it works, everyone? Just look around you. These are all real. This building is real. There's engineering studies. They did it. And sometimes they make mistakes and there are flaws and the building collapses. But meanwhile, we went to the moon, all these things. It's science. It's technology. If you want to tell me that's not objective, I'll say fine, but they still went to the moon. So I think it's really important for us to start thinking about this in a way that doesn't get caught up in, it's either absolute universal immutable truths, or it's whatever you want, or there's nothing, it's subjective. It's that framing that is the mistake. I do not believe either alternative is real, and therefore we should stay and recognize the limitations of what we do. At the same time, we recognize the validity of what we do and how it produces results that we can, going back to the pragmatists, rely upon to achieve our objectives, to achieve valid knowledge about the world.
Okay. Thank you so much. I just want to add that a word where we would be guided, where our conduct is guided by law entirely, would look like hell. So yeah, Latour would say that. Yeah. Now we have a couple of people. We have Professor Aranda, Professor Barwale, and someone else, maybe Professora Paula Ahumada, and that's it. First.
Let me just quickly, I just want to follow up because there may be a misimpression from what I said. It's because I'm focusing on law that all of my emphasis is on law. But if you were to ask me what's the most important thing in society, law would not be the first thing that comes to my mind. So I'm not, just because I'm focusing on law does not mean I believe law is everything in all of things. So I believe society is a complex mix of all of these things.
Thank you, Brian, from your wonderful presentation. So my question will be about being a fox, not a hedgehog, and about expressivism. I think I will work it out, but here's a problem, right? Like physicists, they do have a problem with the general equation of physics, right? There is quantum physics and there is this Newtonian physics, and they don't talk. So when, as a law professor, I kind of see the law as a political struggle, as the result of a political struggle. And when I look it back, it's easy how to see that and how conditions or circumstances in the society basically shape how that law works. So I can do always the kind of the genealogy of it and diagnose the present using empirical studies. And I also want the law to be efficacious some way. So I also use empirical stuff and read a lot of empirical stuff to inform what I suggest the law should be. But then when I look forward, expressivism comes somewhat in the equation, and I'm just saying, well, but I do want things to go that way. And basically, I don't have very good facts or any empirical ground to push things that way. But then I'm not at all pluralist when I'm looking forward. So I think basically I'm being consistent because I change when I look at the law of what it is now or what it was and then what I want it to be. And I'm like the physicist with two different equations, looking all the time forward and backward, and somewhat troubling. One would expect that a philosopher of the law would help you to solve those difficult questions. So there it is. Thank you.
Yeah. I understand your dilemma. And for me, these go together, and they go together in one sense. Let's say I have a vision of what I think is good, and I want to persuade others that this is something our society should try to achieve. That is being then led by ideals, right? Goals that you have. So that's one side of it. But the other side of it is to be able to achieve those goals, we need to figure out what the current situation is. We also need to figure out how best to achieve those goals. Those two parts, what the current situation is and how best to achieve those goals, those are empirically grounded. It has to be. And so these are not antithetical. They're more like complementary stages in achieving ideals. Now the question is, well, what about the ideals themselves? That is in a different realm in the sense that now we have to engage in normative discussion, normative political, moral argumentation, discussion, persuading others that these are good goals to have, that they're beneficial to people, and that they should agree that these are good goals to have. For example, in the United States, we should have a better minimum welfare for people who don't have health care, for people who pay. That takes place, that discussion takes place in the moral political arena. So my view is that you're right in that there's a disjunction there, and yet I also think that the disjunction is unified in the sense that to the extent that those goals are important, the only way to achieve them is to understand what the current situation is and how best to take that path. All of which, by the way, is open and speculative. And so another theme in pragmatism is experimentalism. A main idea, if you were to ask me who's the main flow within these ideas, I would say Dewey and me in a different way. And Dewey was all about that experimentation. You have to try. You have a law reform you want to put into place for X reason, put it into place, but monitor the consequences of how it works. This is where the law and society stuff is a necessary complement to achieving these goals. They also believed at the time that science had could assist us in understanding the normative views themselves, evaluating the normative views themselves by seeing whether when the outcome occurs, did it work out the way you wanted? Let's say you did achieve that. Oh, but actually there are unanticipated consequences or the results weren't as good as we want. But there will not be the empiricism aspect of that helps us understand and evaluate our norms, but it's not going to tell us what the right answer is in that sense. Those normative orientations are generated by us within society in the context of moral, cultural, political views. So this is a long way of saying I feel your sense that these two things are not quite flowing, and yet I want to resist that and suggest that they're actually complementary at a certain level, but not one in which you're going to answer all questions. It's just the nature of knowledge and normativity.
Professora Aranda and then Professora Ahumada.
It's supposed not to talk about your explanation. Thanks for everything, Professor Tamanaho. I trying to follow your topics. I'm involved with environmental law, and most of my daily job is about environmental procedure. I remember you said about the impossibilities of transplants. It's a complicated topic for me because when you are studying environmental law, you can detect at different levels a transplant. For example, about environmental impact assessment. Most of countries in the world have an environmental impact assessment, and it works well for example, at the state level, and every country has an environmental impact assessment. It works, more or less, could be effective or not, but we have the same idea in an idea of institution. An application the same way at the state level. Many countries try to go on and assessing impacts, environmental impacts, and preventing many damage to the environment. Yeah. But in a social recognition, at the bottom of the level, there are some social expectations that this match or not match what is in the theory is, what the state level is. And my question is how it works. We have not the same recognition of the same instrument, of the same environmental tool, but sometimes seems like a transplant we have the same idea of, but implementation is sometimes it match with expectations and sometimes not. And my point is, in some countries, transplant works, in others not. And my question is, why?
So yeah, I didn't mean to say that you cannot transplant. In fact, if you look at the history of the development of law around the world, it substantially involves transplantation. So that's, I think, the reality. And we can talk about civil law systems. They exist all over the world, right? Civil law systems. And there's another set, and that's common law systems. They exist all over the world too. That happened through colonization, but also voluntary borrowing. Right? Systems wanted to develop, so they created code. Well, there's a code, let's use that one. And there are many examples of that. So law of transplants, the only point I was trying to make, or I should say, the point I was trying to make is that when you transplant law, it doesn't work the same way. So you can transplant, but the way it works out is different. And the reason it works differently is that the law from a particular jurisdiction, one of the claims I was making about holism is that law is integrated within society. And it evolved within, that's historicism, it evolved within that society. So the common law is the product of English and American society over time, over centuries, right? So we pluck out those doctrines and then we move them to another place, like Micronesia. They had law over there. It was a common law system. That was because they were American, run for 50 years during the Trust Territory. But when they took that law and they had law, that law wasn't playing out the same way. And I'll just give you an example. The particular place I was at had a very still in operation caste system. Yet their constitution, which was written by Americans, protection clause, everybody's equal. Okay. You could say everybody's equal, but they're not under their social system. So what you have is this complex interaction between a set of social views in which caste system was entrenched culturally, and yet a legal constitution that said no, everybody's equal. So, and I can give you many examples, but it's a striking one. So the point I was trying to make is that the law emerged integrated within one society, and in that society it was supported by all the things around it. It's plucked out, it's put into another one, and now it has to swim in a different sea, to put it in a metaphor. And therefore, how that interacts in that different sea is kind of hard to tell. We don't know exactly. But one thing we will know, pretty good, confident reason to be confident is it's not going to work like it was there, because it doesn't have all the surrounding institutions and support that it had there in the society of origin. Now, in terms of environmental law, I just don't know enough about it. All I'm saying is we could have the same institutions in officially on paper, but must recognize that it won't work the same way in reality. And now I'm not talking about law only. I mean, I think that pretty much applies to any of these things that we're doing. So I'm sorry it can't be more helpful, but I think that's just the way it is. And I don't think there's any generalization that you could say beyond saying, well, it won't be the same. Which isn't to say it won't work. I'm not saying it won't work at all. It will have effects. It will have consequences. Just not exactly the same.
That's great, Professor Paula Ahumada.
Well, thank you, Professor Tamanaha. My name is Paula Ahumada. I'm a professor here at the law school. I have a short question and two questions. One is if you could explain the difference between the socio-legal approach and legal realism, because I've always find myself very compelled by legal realism because, like as you say, like looking to interests and also to ideals, to power relations, but I cannot like really see the distinction. I know there are a lot of legal realisms too. I'm thinking about especially the US based legal realists, and the one that is not based on psychological approach to law, but more the one that is more about political economy and the relationships with the law. The other question I have is that I really enjoyed your presentation, but in terms of the holism you see in how law works, I teach introduction to legal theory class for first-year students, and I usually start with this quote that is that law is like the air we breathe, you know, it's everywhere. But also I think that it has like a sort of autonomy also. It's not the same as politics. It's politics influences the law, but the law has a certain logic that's different. So what's your view on that? And finally, one of the things that also interests me is the, of course, the democratic backsliding and how authority has been in decline all over. It's not a Chilean thing, it's all over the world. So how do you see like the legitimacy in terms of what's behind the validity of the law? Because in terms of Weber, you know that the modern state is based on legal rationality, but I believe that legal rationality is the thing that is being like decaying. Thank you.
So it's, thank you for mentioning Weber. The part of the talk that I cut out was about Weber. I mean that because, so if I were to, let's just talk about law in modern society for a moment. In my view, modern societies, and if you read the sociological literature, this is, everyone agrees. Modern societies are societies of organizations. The entirety of what we're studying is and laws and organizations all have the same structure, basically, and that's bureaucratic, hierarchical organizations. And there's a kind of rationality built into organizations. So now let's shift to law. Law, as you said, has a kind of autonomy. I think that's correct in an important sense. Not autonomous from society, but separateness in one sense. So this isn't autonomy as in floating free in the air. No, it's not. It is mutually constitutive, as I suggested earlier. That puts it back into society. However, there's certain aspects to law that are built around legal specialization, legal ideals, legal technology. Those things that we learn in law school, that I learned as a law student, right? How to make legal arguments, what the rules of tort. I teach tort law, by the way. I teach positive law. That's what I do. And I was a lawyer, and I needed to learn those things, or I could not function as a lawyer. Now, lay people don't actually know what those technical elements of law are. So law is a highly specialized built body of knowledge, institutions, and practices. That specialized knowledge and institution and practices are what we call positive law. And we learn that in law school. We go out and we do that as lawyers. I did that for the first 5 years of my career. That's real. That is absolutely how law is constructed. Now, where lawyers, I think, or legal theorists go wrong is not understanding that that element itself is still embedded within society and needs to be understood in relation to everything else around it. But that's not to deny that it does have a separateness in some sense, and the separateness comes from legal specialization. I think today, another way to think about it, in my view, and this is how I've been trying to develop it, is that law has formed. Now, again, I want to caution what I'm talking about because there's so many different arrangements in society. I just want to talk about law in advanced capitalist societies, which I believe Chile is, but certainly the US and other places. In these societies, so in law and advanced capitalist societies, in my view, or a view I've been trying to develop, form a kind of background infrastructure for all transactions, all social interaction. That background infrastructure, I can give you just a simple example. So enabling acts is law that creates things, like real things. So enabling act is like a legislation that created the Department of Homeland Security. When that law was passed, before that, there was no such thing. When that law was passed, magically, the Department of Homeland Security was created. Now, it had to be filled in, had to get budgets and so forth. At the same time that was created, they abolished pre-existing institutional arrangements. So that enabling act was supported by termination acts. This is law doing things. This isn't just law as a bunch of rules. This is a performative action by law. By making this declaration, we create it. Now, there's another example. And that example is enabling acts for corporations, right? Enabling acts in the 19th century in the United States, to get a corporation, you needed specific legislation. That's why they didn't have that many, because the legislators would have to enact. So they made individual bills. And then in the 19th century, they created general laws of incorporation that allowed people to go in, fill out a bunch of forms, pay the fee, and magically your corporation exists. Now still, it's only a shell, but it's a legal shell, a legal personality. Now the reason I'm mentioning those two, enabling acts by government and enabling acts in relation to corporations, is, at least in the United States now, the vast majority of organizations, the ones that matter, there's lots of smaller ones, there's lots of institutions that are not created by enabling acts, but I'm just talking about the big stuff, are legal creatures. Now let me go inside of that. Contracts, how do corporations operate? Well, they operate through contracts. With who? With their employees, with their suppliers, with their financiers, with the banks. All of this is contracts, all of this. Now let me get outside of corporations and talk about us, people. At least in the United States, I don't know about Chile, but I'll just say, we have contracts everywhere. In fact, every time I buy something from the internet, I'm signing a contract. But guess what? I never read it, and nobody does. Why? Because it's a background infrastructure. And none of those are negotiable anyway. And these are all, as we say, boilerplate, right? The only things we're really arguing for is quantity, price, like fundamental things. I mean, specific things that I care about, I should say it that way. So what my point is this, that we go along in society, and this is now what I'm trying to describe as the infrastructure of law. And I'm only talking about advanced capitalist societies. There are a lot of societies that are not like this. They don't have that much law, not this much. So we go about our affairs just simply assuming that law is in place if something goes wrong. And meanwhile, and I have assumptions about what that law is. Now, I'm an educated lawyer, so I know a little bit more, but even I don't know what all that is. And it doesn't matter. What matters is that we are able to engage in our social and economic interaction is a big part of it, in which we figure, okay, there's a contract somewhere. Hopefully this is going to work. And the only time it becomes an issue is when something breaks down. And then we go, oh no, now I got to get a lawyer. And what we find, and this comes out of law and society, is many people just lump it. They don't go to lawyers. Not worth it. So if you get the picture of what I'm saying, what I mean by background infrastructure is that lots of our legal arrangements are there in the back. Meanwhile, we're all interacting with a kind of sense of security that it should work. For the most part, it does. And lots of times in the US, if you get a product you don't like, just send it back. They'll send it to you because it's not worth it. It's not worth the trouble for the corporation. So it's not even clear who's in the right. It's like either you lump it, you say forget it, or they just resolve it into their own way. By the way, Stuart Macaulay's, in business relations, they go, no, let's just solve it. Why? Because people want to interact. It's much more worth it. So they don't go to law, because if you go to law, you're seen as a troublemaker and so forth. So when we think of law in this positivist sense, I think it's really important, but maybe not the exact way we think it is working. It's working another way. It's not guiding people, because people don't know what the law is. And they're often not resorting to the law because they don't want to. Why? Because it costs a lot of money. It's not worth it for me to do. But it functions really usefully anyway, as sort of something to fall back on in case of trouble. And then some really critical times, I will go if I have to. You know, I got fired because you didn't like how I looked. Okay, now I'm going to get a lawyer. So it's there to be called on, but for the most part, it's not called on, and it's functioning. That vision of law that I just articulated, I don't see discussed anywhere. And I actually think that's really what law is really doing. I tried to lay this out in a book called A Realistic Theory of Law, in which I talk, and I don't say much about legal pluralism there. I'm talking about law in modern society, advanced capitalist societies, and I lay that out. And that brings me to your first question, and that is about realism, legal realism. Legal realism, if you were to asking me, what's the difference between this and legal realism? I'm going to say, well, you can call this legal realism if you want. Legal realism was a specific label for something that emerged in the 1930s. In fact, you can identify the emerging moment, the debate between Carl Llewellyn and Roscoe Pound. And Roscoe Pound's response to Carl Llewellyn, we have the letters, said, what are you talking about legal realism? You can put all of us in there. We all believe what you're saying. And when I read that, I was kind of shocked. I mean, it's hard to distinguish what Llewellyn was saying from what Pound was saying and sociological jurisprudence was saying. And that's what Pound said. Why are you making like you guys are somehow, you know, avant-garde revolutionaries? We've been saying this for a while now. So if we talk about legal realism as a noun, the name of a school of thought, I can identify for you very specific things that was said. The starting point is Llewellyn's articles. He wrote a couple, but realism about realism. I mean, he named a bunch of people, but the ideas that they were espousing were not unique at the time and had predecessors. And those predecessors, I will tell you, were in sociological jurisprudence and in historical jurisprudence, which is why in my work, I've not like settled on legal realism, but instead gone to the more fundamental views that were being espoused at the time, which I think honestly come to the same thing. So I'm not rejecting legal realism, but trying to approach this in a broader, more encompassing way, in which legal realism is a piece of it, but not the whole. But you are right to say, well, the legal realists promoted social scientific studies of law. Of course they did, but so did Roscoe Pound. And Llewellyn attacked Pound. Okay, how do we think about that? So, and when I say you can, if you're going to ask me what's the difference with legal realism, I'm going to say, well, my book is called A Realistic Theory of Law. I'm using that label because I think it correctly, it's a good description for what I'm approaching. So I would say, I don't think there's a fundamental difference.
Well, Professor Francisco Agüero, no, okay. Does anyone else have a question? Professor Paulo Ahumada, does it answers your concern? Right. I have a quick question though, a last one maybe. When you answered Professor Barroalé, I thought when he talked about expressivism, you would answer a little bit with your idea about your critique of the idea of the mirror thesis. Mirror thesis. If you could just explain a little bit your take on your critique about this idea, this Luhmann idea of two separate spheres, which are called society, and the other one would be law, and they reflect each other. If you could just elaborate a bit on that.
I think the mirror thesis is really a fancy word for an assumption that we have often had. And that assumption is often true, that law reflects society. The only objection I had is that it doesn't always reflect society. Sometimes it's leading society, sometimes it's the opposite of society. what is law reform except the idea that I want to change society? So how can it be a mirror if it's trying to change society? Lots of laws are declaring this is what law requires, but the big theme in law and society is the gap between law and society. So how can it be a mirror? The point is, in general, law is integrated within everything, but I was just trying to open space with the idea that, well, it doesn't always mirror. What you have to do is actually look and ask yourself, is it consistent? Is it mirroring? By the way, and there are lots of reasons. I've just given a couple, but I'll give you another one. Transplantation. It's not mirroring society with transplantation, and laws been transplanted everywhere. I'll give you another one. I would criticize the guidance function of law. Right? How did I criticize it? By saying that they have all these studies that show people have wrong ideas about what the law is. They have wrong ideas because they assume law is consistent with their cultural and moral views, but law is not. That's just another grounds in which law is not mirroring society. It's not matching what their assumptions about law are. So I think there are a range of ways in which law does not mirror society. And that was such a kind of often repeated view that I thought that that it's good to have a healthy distance from that view without totally rejecting it. If law is interconnected within society, as I said it was, then it has some elements of consistency. Otherwise, it couldn't be integrated within society. It's just not a postulate I want to say is somehow a fundamental principle that's a given. In fact, I think that we should have that as a question rather than an assumption. I think you mentioned Nicholas Luhmann. Did you mention Luhmann? Okay, I don't want to say much. That is not a short question, but I just want to say something about Luhmann. Luhmann's analysis, autopoiesis, this whole thing, Gunther Teubner, this is a very highly sophisticated sociological theory based on functionalism. I believe functionalism is not, functionalist sociological theory is not an illuminating way to understand society. Now, having said that, one of the points I make about pragmatism is that all theories just are different frameworks for helping us look at things and figure them out. And theories can be rejected or accepted based upon what your objectives are. So can there be certain insights produced by autopoiesis? Absolutely, there are. But the whole shebang, the whole theory, no. And this is only my decision. I mean, others, obviously, they're devotees of it. I'm just not one of them. So I'm not rejecting it in total. I think just on balance, in terms of the questions we have about law and society, that's not the most productive theoretical framework that's going to unpack these questions and allow us to examine them. The questions that I tried to cover in this talk and in my work can't be examined through that framework. So that particular framework is kind of high sociological theory. For me, is less useful to jurists and everyday people. And the perspective I'm trying to bring to play is trying to talk about law in a way that enables people and jurists and people engaged in lawmaking to answer the kinds of questions that they want, the ones that they're dealing with. So I'll stop there.
I just want to acknowledge and thank you and give a huge applause to Pablo Fuensalida and Esteban, our organizers from the postgraduate school.
That's a great work, Pablo.
Well, I think it was great. And now we could take a picture and the last session, I think with a lot to chew on, and then we could maybe have lunch and actually chew on something material. Thank you so much. Thank you. Fotógrafo, ¿dónde fue? Perdimos el fotógrafo. Foto. Una foto de todos. Ahí, there. Pablo, solo cerrar, ¿no es cierto? Solo cerrar.